Hello and welcome to LiveLaw Daily, your no-noise roundup of everything that happened in India's courts today. Today is the 14th of July and it's been another packed day. Delhi's courtrooms were quieter than usual and the Supreme Court, weighing in on everything from a Bollywood residence to a decades-old political scam, was very busy itself. So let's see what happened today. For the first story today, should humanitarian considerations outweigh the risk of an accused not returning to face trial? That's the question the Delhi High Court had to answer in a case involving a senior Vivo executive. Justice Madhu Jain refused permission to Guangwen Quang, also known as Andrew, an accused in the Enforcement Directorate's money laundering case against Vivo Mobile Communication, to travel to Guangzhou, China. This was to visit his 82-year-old father, who is reportedly on life support after suffering a brain hemorrhage. Before the court, Andrew argued that his request was made purely on humanitarian grounds. He said he had cooperated throughout the Enforcement Directorate's investigation, appeared before the special court whenever required, and undertook to return to India within the time fixed by the court. The Enforcement Directorate, however, opposed the plea, pointing out that Andrew is a Chinese national facing prosecution under the Prevention of Money Laundering Act in a case involving alleged proceeds of crime exceeding 2 lakh crore rupees. It argued that since India and China do not have an extradition treaty or a mutual legal assistance treaty in criminal matters, securing his return would become virtually impossible if he chose to not come back. Accepting the ED's submission, the High Court held that while it was conscious of the humanitarian circumstances, such considerations could not override the interest of justice and the need to ensure the accused's presence during trial. The court also noted that the undertaking furnished on Andrew's behalf was not legally enforceable, and no assurance had been given by the Chinese consulate or any diplomatic authority guaranteeing his return. For the second story today, a rare scene unfolded inside the Delhi High Court where the president of the Delhi High Court Bar Association asked lawyers not to argue. Senior advocate N. Hariharan, president of the Delhi High Court Bar Association, urged advocates to abstain from appearing before the High Court in protest against the proposed increase in the pecuniary jurisdiction of Delhi's district courts from 2 crore rupees to 10 crore rupees. The appeal was made before a bench headed by Justice Naveen Chawla, where Hariharan requested lawyers to stand by the bar's cause. He warned that the proposal could eventually affect even the criminal side and appealed to members to support the association. The court, however, observed that it was not insisting on anyone arguing their matters. A similar exchange took place before Justice Harish Vaidyanathan Shankar. As some lawyers continued to appear, Hariharan urged them to cooperate with the one-day abstention, saying the bar could not carry the movement forward without the support of its members. Responding, Justice Shankar remarked, "You are doing your job, we are doing our job. My job is to dispose of as many matters as possible." The Delhi High Court Bar Association says it has opposed the proposal because it believes increasing the pecuniary jurisdiction would have far-reaching consequences for the justice delivery system and the legal profession in general. According to the association, nearly 70% of the Delhi High Court's original civil jurisdiction could be transferred to the district courts if the proposal is implemented. And for a third story, Shah Rukh Khan's Mannat has become one of Mumbai's most recognizable landmarks. But today it found itself before the Supreme Court, and it was over a challenge to environmental clearances granted for this property. The Supreme Court declined to interfere with the Coastal Regulation Zone, or CRZ, clearance that permits the addition of 2 more floors to Mannat, which effectively dismissing an appeal against an earlier order of the National Green Tribunal. The appeal was filed by Mumbai-based activist Santosh Daundkar, who alleged that the approvals were illegal. According to him, the project was connected to earlier CRZ violations. Heritage structures had been demolished without environmental clearance. The property was originally reserved for an art gallery and it ought to have been classified under the more restrictive zones of categories than it was put under. Appearing for the petitioner, senior advocate Shoaib Alam argued that the matter should not be viewed differently merely because it involved a well-known actor. He also told the court that Downkar had earlier exposed the Adarsh Housing Society scam in Kolaba and was a respected activist himself. The bench, however, clarified that Shah Rukh Khan's celebrity status had no bearing on its decision. It noted that the National Green Tribunal had repeatedly asked the petitioner to identify any legal or procedural defect in grant of the CRZ clearance. Instead, the tribunal found that the challenge largely repeated allegations without establishing any flaw in the approval process. Finding no reason to disagree with the tribunal's conclusions, the Supreme Court dismissed the appeal, allowing the CRZ clearance for the proposed construction at Mannat to remain in force. And for the fourth story today, the Supreme Court was asked to decide whether RJD chief Lalu Prasad Yadav should continue to enjoy the suspension of his sentence in the Deoghar Fodder scam. The court's answer was no, but not in the way the state had hoped. A bench of Justice M.M. Sundaresh and Justice P.B. Varale declined to interfere with the Jharkhand High Court's 2019 order, which suspended Lalu Prasad's sentence. At the same time, noting that his criminal appeal has been pending since 2018, the bench requested the High Court to dispose of it within 6 months. Appearing for the state of Jharkhand, Additional Solicitor General S.V. Raju argued that the High Court had wrongly concluded that Lalu Prasad had completed 50% of his sentence. According to him, since Lalu was convicted in multiple Fodder scam cases arising out of separate trials, Section 427 of the Code of Criminal Procedure would apply, meaning the sentences should run consecutively unless directed otherwise. He argued that the High Court had incorrectly treated them as running concurrently while calculating the period of imprisonment. During the hearing, Justice Sundaresh asked about the status of the pending appeal, to which the state responded that it had not been heard and alleged that the delay was attributable to the accused. Opposing the state's plea, senior advocate Kapil Sibal, appearing for Lalu Prasad Yadav, argued that Section 427 was being invoked at the wrong stage. He submitted that whether the sentences run concurrently or consecutively is an issue to be decided at the final hearing of the appeal, and that the High Court had merely exercised its discretion by following its consistent practice of suspending sentences after an appellant had completed half of the sentence. Taking note of the long pendency of the appeal, the Supreme Court refused to disturb the suspension of the sentence and instead asked the Jharkhand High Court to hear and decide the appeal as expeditiously as possible, preferably within 6 months. And for the fifth story today, the Bhojshala Kamal Maula dispute is back before the Supreme Court, but for now, the court has chosen to maintain calm rather than alter the existing arrangement. A bench comprising Chief Justice of India Suryakant, Justice Joymalia Bagchi, and Justice V. Mohan issued notice on petitions challenging the Madhya Pradesh High Court's order, which held that the Bhojshala Kamal Maula complex in Dhar is a temple dedicated to goddess Saraswati and effectively prohibited the offering of Namaz at this site. The Muslim parties urged the Supreme Court to restore the earlier arrangement under which Hindu worship and Friday Namaz were both permitted on designated days. Senior advocate Huzaifa Ahmadi argued that a practice which had continued for centuries had been disrupted, while senior advocate Meenakshi Arora submitted that both communities had peacefully shared the site for decades under the 2003 ASI arrangement, that is the Archaeological Survey of India arrangement. She questioned why such an equilibrium should be disturbed after nearly 800 years of worship. The Supreme Court, however, declined to pass any interim order, restoring the earlier status quo. Chief Justice Suryakant observed, and I quote, "Let us not pass any order which can create tension," adding that the earlier arrangement existed only while the character of the site was still under adjudication, whereas there is now a judicial determination by the High Court, whether right or wrong. At the same time, the bench directed the Madhya Pradesh government to provide the Muslim side with a separate open space adjacent to the complex to offer Friday Namaz between 1 p.m. and 3 p.m., making it clear that this is only an ad hoc arrangement and will remain subject to the final outcome of this case. The court also directed the Archaeological Survey of India not to carry out any structural changes to the monument without its prior permission and indicated that the matter will be listed for final hearing after 3 weeks. For the sixth story today, if you search someone's name on a legal database, should court judgments involving that person still appear? That question is now before the Delhi High Court. Legal database platform Indian Kanoon has challenged a recent single judge judgment that recognized the right to be forgotten as a constitutionally protected facet of informational privacy under Article 21 and directed search engines and legal databases to de-index and disable name-based searches for certain judgments, orders, and news reports. The appeal came up today before a division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya. Appearing for Indian Kanoon, Advocate Naman Gupta sought a short adjournment in view of the lawyer's abstention from work, following which the matter was listed for July 21st. In its appeal, Indian Kanoon argues that the single judge ruling goes too far and undermines the constitutional principles of open justice and the public's right to access judicial records. It contends that once such information becomes part of a public court record, the right to privacy ordinarily does not survive, except in recognized categories such as sexual offense cases, juvenile matters, and other protected proceedings. The platform has also argued that name-based searches are essential for lawyers, litigants, researchers, students, and even judges to locate precedents. According to Indian Kanoon, restricting such searches not only hampers legal research, but also disproportionately affects its business and its right to carry on trade under Article 19(1)(g) of the Constitution. For the seventh story today, can a convict seek suspension of sentence simply because they have already spent several years in prison? The Kerala High Court says the answer depends on far more than just the time spent behind bars. A division bench of Justice Raja Vijay Raghavan and Justice K.V. Jaikumar has dismissed the plea filed by Sunil N.S., also known as Pulsar Suni, seeking suspension of the 20-year sentence imposed on him in the 2017 actress sexual assault case. The bench observed that once a person has been convicted, jail is the rule and bail is the exception. It said that there is no longer a presumption of innocence, and before suspending a sentence, an appellate court must record strong, cogent, and compelling reasons, while considering factors such as the nature of the offense, the manner in which it was committed, its gravity, societal impact, and the need to preserve public confidence in the criminal justice system. The court also rejected the argument that Suni had already spent more than 8 years in custody, holding that long incarceration by itself is not a ground to suspend a sentence. Referring to the trial court's findings, the High Court described the manner in which the offense was committed as unprecedented in its nature and execution. It noted that the crime had shocked the collective conscience of society and that releasing the convict would undermine public confidence in the rule of law. The bench also took into account Suni's criminal antecedents, his alleged involvement in another criminal case while on bail, and violations of bail conditions before concluding that no exceptional circumstances existed to justify suspending his sentence. And finally today, what languages should Indian students be learning in school? It's a question that has sparked a nationwide debate, and today it reached the Supreme Court. The challenge is to the CBSE's new 3-language policy for the 2026-2027 academic year, under which students from class 9th onwards are required to study 2 Indian languages as part of the 3-language formula. Appearing for one of the petitioners, senior advocate Anand Grover argued that the CBSE lacked the legal authority to introduce such a policy, contending that academic requirements could only be framed by the NCERT. He also questioned how students could realistically choose different Indian languages when many schools lack the necessary teachers and textbooks. As he put it, if a student wants to study Punjabi instead of Sanskrit, where are the teachers and books? Senior advocate Gopal Shankar Narayanan echoed those concerns, submitting that the policy effectively treats English as a non-native language while compelling students to opt for Indian languages. He pointed out that the NCERT website currently hosts textbooks for only 3 languages, even though schools are expected to offer many more. He also warned that the sudden shift could put teachers' jobs at risk if schools are forced to change their language offerings. Responding to the submissions, Chief Justice of India Suryakant remarked that learning a language never goes waste. And when concerns were raised about teachers being dismissed, the Chief Justice quipped, "If dismissed, we can reinstate." And for now, the Supreme Court has declined to stay the CBSE's 3-language policy, issued notice on the petitions, and will hear the challenge in greater detail next week. That wraps up LiveLaw Daily for today. But make LiveLaw Daily part of your routine. Every day, here and you're caught up on the most important stories from India's courts. Check the description box for the full stories, hit subscribe, and we'll see you right back here tomorrow.